Good afternoon, everyone. Thank you for being here. This is a further hearing in the matter of Rosemary Blair versus Joseph O'Donnell and Carla Bowers.
The day has finally come. Part 4 of Judge Middleton's case. Whose house is it? Everyone had predicted that this would take more than one day. Judge Middleton had said that if he set aside 5 days, it still wouldn't be enough. But we aren't sure anyone could have predicted what actually happened. And perhaps we should have. It is exactly the way this has gone from the beginning. If you have not seen the previous parts, it is well worth your time to check them out. We will include the links in the description. So, before we ruin the surprise, let's get into the video.
So let me call the case again. It's entitled Rosemary Blair versus Joseph O'Donnell and Carla Bowers. The file number is 221862. At least that's the original title of it. There's a counterclaim that's been filed, and there are pleadings with various names on it. But the original case had to do with the lease option to purchase a property at Corey Lake. It started as a termination of tenancy matter under summary proceedings, and it's evolved into a much larger case. Attorney Matthew Hauser is here on behalf of the plaintiff Rosemary Blair. Daniel Hatch is here on behalf of Joseph O'Donnell and Carla Bowers. All those parties are present. This was the time and date for a hearing on plaintiff's motion to set aside a default and for damages from the counter plaintiff, defendant O'Donnell and Bowers. As I mentioned in chambers, I spent a good deal of time on Wednesday going over all the pleadings. It now fills a whole box. As I mentioned last time, I reviewed the personal protection order matter. I reviewed the zoning enforcement matter. I reviewed the original summary proceedings matter. I watched the videos of the previous hearings and felt I was in a position to address the issues. Yesterday, I received a motion from Mr. Hauser, motion to withdraw as attorney for counter plaintiff pursuant to the court rule. Mr. Hauser, would you like to speak to that?
Just briefly, I would do stand by.
You could stand at the podium there, and then you'll be in frame for the camera.
There we go. We would stand by the pleading that was submitted to the court yesterday. At this time, it's been indicated to me that Miss Blair wishes to seek a new attorney on this case, and therefore we would also request that any further proceedings before this court scheduled this afternoon be adjourned to allow Miss Blair the proper time to obtain new counsel, as we feel her moving forward at this time would be prejudicial to her, as there's quite a bit on the court docket for this afternoon. Thank you.
All right, thank you. Miss Blair, you no longer wish to have Mr. Hauser represent you in this matter?
Correct.
You have no objection to him withdrawing?
Correct. I have no objection.
In fact, you wish him to withdraw?
Yes.
Mr. Hatch, what's your position?
Your Honor, I have no objection to Mr. Hauser withdrawing as counsel. I just do want to put that it's been nice working with Mr. Hauser. It's been a difficult case. I think he's done a good job on this file. I do have an objection to an adjournment of today's hearing. MCR 2.503B requires good cause to adjourn a hearing. Number one, that was not cited in Mr. Hauser's motion. There's no evidentiary or factual support for it. The case sites are Zerillo versus Dykehouse, 191 Mishap 228, and Enri Kruger Estate, 176 Mishap 241, which establishes the good cause requirement. So Mr. Hauser is Miss Blair's third attorney to start out with Mr. Yonker, who the letter was sent to my clients on behalf of Miss Blair, illegally evicting them from their property. Then she moved on to Miss Lori Hines, who either withdrew as counsel or was terminated. And now she's moved over to Mr. Hauser as her third attorney. We are here at today's hearing to establish after a default our damages. Miss Blair, Mr. Hauser, at the direction of Miss Blair, filed a motion yesterday, the day before the hearing. So I think it's incredibly inappropriate to adjourn today's hearing and really just offensive to our system, because now we've been here 4 times in front of the judge, spent a lot of money for today's hearing, and there's not good cause to adjourn today's hearing. If Miss Blair wants to represent herself, she is entitled to do that. I'm sure there'll be a continuation of today's hearing if she wants to try to seek counsel. But the case was filed by Miss Blair in December. And again, there's no good cause to adjourn the hearing, Your Honor. So no objection to withdraw as Mr. Hauser, but we would like to proceed today.
Any further?
The only thing that I would like to add is, since the April 27th hearing before this court, the defendants / counter plaintiffs have been in full possession of the property in question. If this matter is set over for a brief adjournment, they will be able to remain in the house. They have their wishes met, and Ms. Blair can be adequately represented by a new attorney in what, as everyone knows, is a rather complex matter that we now find ourselves in. If she was to continue improper at this point, I do not believe she'll be able to adequately represent herself moving forward today. Thank you.
Thank you. Well, Mr. Hauser, I don't want to leave you in a position where you got 1 foot in the case and 1 foot out of it. So I'm going to grant the motion to withdraw. I've enjoyed having you in this case. The pleadings here are very well pled for many issues. You've been easy with the court to work with on this difficult case, but I don't want to buy you a grievance. And so I'm going to allow you to withdraw. And at this point, you don't have anything to say about anything. So one may argue that good cause for an adjournment is the fact that I don't have a lawyer. But the reason I don't have a lawyer is because I don't want this lawyer. And oh, by the way, I told you about it 1 day before this complicated hearing where we blocked out a large amount of time. And as I expressed to the parties, I don't want to do this twice, and I don't want to increase the price. So, Mr. Hauser, you're excused. I don't want to leave you with ethical dilemma.
I can't.
All right. So, yeah, you fired him and he withdrew. So you're free to go. And then we'll discuss what happens next. I put you in an ethical problem if I make you argue and then she's expressed she doesn't want you as her lawyer. All right, thank you. I will see you again sometime, and you're always welcome here in this court. All right, Miss Blair, now here we are. This is your third lawyer, and they are arguing that it's unfair that yesterday in the afternoon, I don't know when the clerk brought it to me, about 2 o'clock, after I spent hours and hours on Wednesday and Thursday preparing for this hearing, that, oh, by the way, I want to fire my lawyer. He made an argument that Mr. O'Donnell has been granted possession of the premises pending the final decision. But there were 2 things set for hearing today. One is the motion to set aside the default, which your lawyer filed. a default entered because an answer wasn't filed in a sufficient amount of time. In addition to the default, I made some findings that they were entitled to relief on the substance. One of the things I found is that the action that you used to remove them from the house violated the Michigan lockout statute. The pretext of condemning the house to remove them from the premises, I found violated the lockout law. In addition, he filed a lengthy counterclaim with a number of counts, which was not answered in a timely manner. So that was on the 27th. The following day, on April 28th, he filed a motion to set aside the default. Well, that was it. It was a one-page state court form to set aside the default. Mr. Hatch filed a response and a brief, and he set forth a statute which has to do with setting aside a default, which is in the 2.603 rule. A motion to set aside the default or a default judgment, except when grounded on a lack of jurisdiction over the defendant, shall be granted only if good cause is shown and an affidavit of fact showing meritorious defense verified in the manner prescribed by the rule. So he didn't file anything to show that good cause was shown or that there is a meritorious defense. So I'm going to deny the motion to set aside the default. Mr. Hatch, you can do an order to that effect.
Certainly, Your Honor. And because
Just a
Mr. Hauser is now removed from the case, I'll do it under a 7-day order, and Ms. Blair is in pro per, so I will serve it upon her last known address.
All right. Now, so that was one of the two issues we had to deal with. All right. The next issue is this issue regarding damages. So you have removed your lawyer. They want to proceed.
I can't defend myself, Your Honor.
Okay.
I just can't. You know, I'm 82 years old. This has been the most stressful year of my life besides the year I was.
So you're asking for an adjournment.
Absolutely. I can't defend myself.
So what do you plan to do?
I plan to have another attorney. I don't know what I can say. I can't.
Well, you can.
I can't tell the truth because it'll all be used against me.
Well, perhaps this isn't a criminal case, but have you talked to another attorney?
Yes, I have.
And who is that?
Bob O'Brien,
From where?
Grand Rapids.
Miller Johnson, I believe, Your Honor.
That's a fine firm. My son declined a job offer from them to do what he's doing now.
I didn't hear you, sir.
But it's just an aside.
Okay.
It's a fine law firm. They have a fine reputation. I don't know him specifically. But they're saying, how is this fair to us? We're here, we're paying our lawyer hundreds of dollars an hour to be here for this hearing. At 2 o'clock the day before the hearing, you say, wait a minute, I want to fire my lawyer. And they're all here and they're ready.
I can't say I can't tell the truth, so because they'll be used against me about the whole thing.
All right, well, let's talk for a minute. The counter complaint has about 12 facets. Some are more relevant than others, but there are a couple of, there's damages, And in theory, not in theory, but when the damages exceed $25,000, the law says I must remove the matter to the circuit court. There's also an issue regarding specific performance. But I believe that's an equitable remedy that normally district courts don't have jurisdiction over. But in a landlord-tenant case, the court does have some equitable jurisdiction. And one of those equitable reliefs is specific performance. That means I order you to go through with the original lease sale agreement.
Nothing yet!
That order that they have the ability to purchase this house for $450,000, which was the agreed upon price. That's one of the things that they're asking for, that this matter be completed. Now, there are issues because the interest rate in the summer of 22 was different than the interest rate now, but he wants me to order you to sell him the house at the agreed upon price. In fact, that may be the primary thing that he wants. There's also a dispute. The defendant claims that he paid, I calculated about $115,000, $85,000 in cash, and then some subsequent payments and some $2,000 a month payments. And then I've ordered escrow. So they're claiming they've paid about $115,000. They claim that $85,000 was given to you. In your pleadings, Mr. Hauser claims she never got the $85,000.
I didn't get all of 85,000, and he was supposed to pay me $4,000 a month. $4,000 a month for 12 months is $48,000.
Now, it does not say that in the lease agreement. This says the amount.
It says zero.
Says zero.
Exactly. I didn't draw up the lease agreement, Your Honor.
Well, you didn't draw it up, but you signed it.
Judge,
I-
I'm just gonna object to the extent that this is part of the hearing to any testimony, I mean, if we want to.
Yeah, well, she's not under oath
Okay,
and we're
I
not
just-
taking testimony,
okay,
but,
okay.
and she's also a layperson doing the best she can, but she bought a firestorm. She fired her lawyer and you're here ready to go. And they've got pictures here. They've got exhibits. There's a picture of you sitting here with a great big pile of green cash. None of this is in evidence yet. I'm interested to know what it's about. They've got charts and graphs, and they're prepared to present evidence on how much money they paid you.
I can't defend myself today, Your Honor. I just can't.
Yes,
You understand?
I do understand, but you caused this problem.
I
You
didn't-
fired your lawyer the day before the
I
hearing.
didn't fire.
All right, well, anyway, whatever happened, the relationship broke down to the extent, and what you told me is you no longer wanted him as your lawyer. So I don't know how that came to an end, but he's not here. And so Mr. Hauser, Mr. Hatch is chomping at the bit to show me all these exhibits.
Well, I can't defend myself today. I cannot.
Yes,
You understand that?
I do understand it, and I don't want to do it twice, and I don't want to appeal it. But you caused this.
I didn't cause it. I'm sorry, I didn't cause it. I have to say it how it is.
All right, well, all right, that's your position, and so I'll respect that.
I never
But-
caused it the first time around, Your Honor.
All right, well, obviously they have an opposite view of it. But anyway, the fact that your lawyer filed a motion to withdraw yesterday at 2:30, you're not blameless in that.
I didn't.
So, and they're saying, look, we took the day off work. We came over here. Our lawyer's here. He's on the clock. We're paying him. We have witnesses here that we're under subpoena, and that's not fair to us. So it'll be an issue regarding costs, but
How can I call these witnesses for me? I don't know.
no, I agree. You're not I'm not being insulting or condescending. You're not qualified to
Right.
represent yourself in this hearing.
Right,
It's complicated. There's a lot of money at stake.
right,
There are rules of evidence, rules of procedure
right.
that are going to apply. And you can't represent yourself. So I could let them go and present everything. And then you could hire a lawyer that would move to set all that aside because you weren't
I don't
qualified.
want to have them do it and hire a lawyer to set it aside. I want to wait till I have my lawyer here. I thought that Matthew Hauser was going to stay here today when we were going to have this. I had no idea what was happening, Your Honor.
Well, no, that leaves him in an untenable position that he's representing you on something where you don't want him to be, and then he could get grieved for it.
I had no idea of any of this until 7:30 on Wednesday night.
All right. I'm also advised that you failed to appear for your deposition.
I was very sick. I had bronchitis.
All right,
and was-
well, there's a dispute as to that, and I didn't give you permission to not appear. It was a subpoena, which was an order from the court to appear.
you know,
And so I have people call up every day and say, well, I didn't feel like coming in today. I didn't feel good.
no, I had a doctor's.
Yeah, I know. And they're talked about the doctor's slip. There are two different signatures, and there was a first letter and a second letter. And so they're suspicious of your doctor's letter. But at any rate, you didn't show up and the deposition wasn't accomplished. And so that'll be an issue that may have to be addressed. Anyway, all of this is expensive.
Are you telling me?
Yeah, I'd hate to see what the legal fees are in all of this before we're finished. And I'm cognizant of that. I'm trying not to run the bill up for each side, but I can't do it, Mr. Hatch. That's fraught with too many problems. You're a fine lawyer. You've got lots of exhibits, lots of rules of evidence, foundational things, people under oath, examination, cross-examination. I can't proceed.
Your Honor, if I may just respond very
Yes.
quickly. Today's hearing is, I would call Joe O'Donnell to testify regarding a lot of the payments that were made between Miss Blair, or excuse me, Mr. O'Donnell and Miss Blair, along with the factual underlying basis for the land contracts. That we're not going to testify about real damages here today because we don't have enough time. I will lay the proper foundation, which is subject to me to avoid an appeal for that. Miss Blair chose to fire her lawyer at the beginning of this hearing. I heard you ask the appropriate questions, and now she claims that she cries wolf, I'm unrepresented. She chose that today. I know Bob O'Brien from Miller Johnson in Grand Rapids, and I would be shocked if he didn't call me yesterday and say, I'm representing Miss Blair. I'm about to represent Miss Blair. Here are some dates that we have available. So if we want to get Bob O'Brien on the phone to see if he's representing Miss Blair, to see if there's an engagement agreement between them. But this is the third time we've been here, and I'm cognizant that the court does not want to create an appealable issue. What we would be going through today would just be documentary evidence underlying the factual legal positions and not anything regarding damages or any conversations outside of what happened between Miss Blair, Mr. O'Donnell, and Miss Bowers. It's as simple as laying a foundation, admitting the evidence, and we can stipulate, and the judge can, you know, if there's not a proper foundation, then you can rule there's not, but I'll lay a proper foundation and we go forward today. And then we can have another hearing that I'm sure based on the court's calendar is going to be probably a month out because you're very busy. Miss Blair can find a representative during that time and he can come to a hearing, he can represent her. She's not calling any witnesses today. I'm just calling Mr. O'Donnell, and it's a couple hours, Your Honor. So I would respectfully ask the court if we could just at least get a couple hours out of the way today and admit some basic documents.
Thank you. It was very well stated, and I understood everything that you just said, but I don't think she did. What you're proposing, it makes sense to a lawyer. I don't want to buy a redo on this. And so I don't have to like it, but she's not gonna even know what we're talking about, laying a foundation and evidentiary hearing. She doesn't understand what you just said. And that's not a criticism. She's not an attorney. So I don't think I have any choice. Now, I had strongly encouraged the parties to settle this case. And Mr. Hatch and Mr. Hauser said they worked diligently on trying to get to a resolution. But they don't get to decide, the parties do. And if it isn't resolved, I will hear it and make a decision. There's a lot of money at stake. They claim they paid you $112,000, which is close to what I had estimated from the proceedings, from the hearing. Now, this started out as a termination of tenancy case. Ms. Hines was indignant and you were being moved out of your house. They were taking things. And then at the first hearing, Mr. O'Donnell and Ms. Bowers showed up. And I said this in chambers, I didn't realize I had handled the zoning case, which was in your name. And you consented to everything. You called them, asked that the property be inspected and condemned, consented to an order, and stop. We're not in school. You don't have to raise your hand, but I'll give you a chance to say something. And then I hear that they use that to remove the people from the house. It was frightening. She's in bed asleep and the cops come and the zoning people come and they're kicked out and then the doors are locked and then we're here in December and then I get his version, our property's missing. I get this notice to quit. I have this agreement and I said, there's more here than meets the eye. I found that was a violation of the lockout statute. I've never seen it done where the landlord condemns the house that the tenant's in and immediately gets them removed from the house. Anyway, so then we're at that hearing. It's like there's a whole bunch of issues. So Mr. O'Donnell and Ms. Bowers hired Mr. Hatch. You hired Mr. Hauser. Things got adjourned. They got adjourned again. They got adjourned because of a tornado that didn't show up. And finding time to hear this has been very difficult. And let me repeat, I denied your motion to set aside the default, or Mr. Hauser's motion. All he did is file a motion without anything more. So that default is in effect. And one of the things in there is a motion for for specific performance, that you sell the house at the agreed upon price. And that's really what this is about. But I'm not going to make you try to defend yourself in this proceeding. She said she talked to Mr. O'Brien. That's different than retaining him or signing an agreement. And he's not inexpensive either.
I'm meeting with him next week. Can I say something, Your Honor?
Yes, you may.
I never had the house condemned. That is an absolute non-truth. Mr. Ard from State Farm, who's a structural engineer.
Your Honor, I'm
Oh,
gonna
yeah,
object
now
to
we're
any
getting,
evidence.
you're not under oath.
Okay,
Yes.
I
No,
never had the house
Your Honor, I'm
condemned.
gonna object again to any evidence.
Well, the house was condemned.
Not by me, I wasn't even
Your
there.
Honor,
All
yeah,
right.
I'm gonna object to any testimony from Ms.
Well,
Blair.
she's not under oath. The house got condemned and Officer Kuhlman testified, I believe that you called him and asked to have him come out there and you consented to the order. I'd have to look at the record from the condemnation hearing, but Anyway,
I never had the house
well,
condemned,
the house was condemned and.
and I had to pay to have it fixed then.
Well, you were the owner.
Right, but
Okay.
they said they were the owners.
Well,
That's
they weren't, they were the tenant.
right.
All right,
So-
that's one of the fundamental issues here. So you're not under oath. I don't want to get into it. But
Right. I
um,
understand, Your Honor. I
but-
don't know what's right and what's wrong to say.
all right, well,
But I do know I did not have the house condemned. And I will tell that to
Your Honor, I would
anybody in the
object
world.
again. I mean, I've heard it 5 times
Yes,
here today.
yes.
She's not under oath, and I'll object to any further statements.
well, and she didn't show up for your deposition where you could have asked her those questions under oath. Well, then who did have the house condemned? Did it just show up out of the blue? There was a little bit of damage on the porch, and the next thing you know, they're crawling into the house, looking at how the window was bottle jacked up. So it was not good. Anyway, that's a separate issue. This is a termination of tenancy. And that condemnation, whether you did it or not, was used by you to terminate the tenancy. Mr. Yonkers sent them a letter
Right,
and said, we're using the condemnation clause of this agreement to terminate your tenancy. You have to move, that your contract is terminated. So you used it to try to
I
get out of
didn't-
the contract.
I didn't use it to get out of the contract, sir. The attorney said that's how it was. Because they
All right, well,
weren't,
stop. That's what happened. The attorney used the condemnation to attempt to terminate the tenancy. But what really offends me is they were removed immediately without notice from the house.
but they
and-
weren't.
Well, I took testimony that they were.
From
So
whom?
from Mr. O'Donnell and Miss Bowers.
They were not.
All right, I don't want to argue with
Okay,
you. She was in bed asleep and they came and they put a condemnation on the house on the 9th of August.
No, it was the 12th of August
12th
when
of
it went on in the
All right.
house.
Well, at any rate,
That I know.
Your Honor, I think that Ms. Blair has alleged capacity issues, but it seems like today she has a very fine memory of the facts of this case. So again, I would just ask that Ms. Blair not testify anything at today's hearing, even if she's not under oath, because number one, a default's been entered.
yes.
So liability's been established. We're here for damages. So again, I would maybe just ask Ms. Blair to
I
listen
don't
to the court.
understand
instead of
any of
And I understand that you don't. So I'm going to grant your adjournment. I don't have to like it, but I'm going
I
to.
don't like it either, sir.
Okay, well, that's,
I don't like it any more than you do.
well, it's unanimous. Nobody likes it.
Right.
Very intrigued by this picture of you sitting with a large pile of cash, which would seem to support their contention that they gave you a large sum of money. It looks like there's a contract, looks like the lease may be sitting on top of the purchase agreement.
Same time, yes. And you can see how my eyes are. I was sick as a dog and they knew it. I have an aneurysm.
Stop. You
Okay,
can't
I'm
keep
sorry.
testifying.
I'm sorry.
All right,
I don't
and
know
what
what-
I said is, on one hand, you said, well, I didn't have the capacity to enter into this contract. On the other hand, that contract was used to kick them out of the house. So you can't have it both ways. And they were gonna present evidence to show that you were competent to sign it. Now, this house, if it went on today's market, would sell for more than $450,000. And that's what's going on here. But there was a signed notarized purchase agreement to sell it at that price. As Mr. Hatch indicated, I have a hard time finding large blocks of time, particularly in the summer. Judge Patterson's gonna be gone, I'm gonna be gone, there are judicial conferences. I have a million things set, so finding a spot to put it is problematic. I'm going to continue this matter for the damage hearing for Wednesday, June 28th at 8:30. Does that work?
It works for me, Your Honor. I just want to check with my clients.
Which gives you about 30 days to get an attorney to come in here and represent you in this matter.
Correct.
All right. Does that date work for you? You don't have an appointment or?
I don't know.
All right. Mr. Hatch,
Ms. Bowers and Mr. O'Donnell are available on the 28th, Your Honor. Do you know what time that would be?
8:30 in the morning. I'm gonna
8:30 a.m.
I'm gonna block out the entire day.
Just for clarification, Your Honor, that would be a continuance of today's hearing, which is a damage hearing on our motion for default to establish default judgment damages, correct?
Yes, so I granted two orders today. I granted the order allowing Mr. Hauser to withdraw. I granted an order denying the motion to set aside the default because they failed to provide a petition of an affidavit of meritorious defense, and they didn't show any good cause. As you indicated in your pleading, you can ask for a continuance rather than default and then afterwards ask for relief. All right, motion to withdraw granted, motion to set aside default granted, defendant's motion for adjournment, defendant's pro per motion for adjournment, and I'll do this order.
I think that was motion to set aside default, Your Honor, denied.
Yes, oh, granted, yeah, denied. Pro per motion for adjournment granted to June 28th at 8:30. And Laura, let's block the entire day. We'll take as much time as we need. Also, I know an apology to Mr. Verpalat. The last hearing we were here, I entered a default against third-party defendant, Mr. Verpalat, because no answer had been filed. Well, everybody sat there. Nobody said anything. I didn't have an answer.
I couldn't hear.
All right, I granted a default against Mr. Verpalat because he had not answered, when in fact he had answered. He had filed an answer with the court in a timely manner, and I didn't know it. And so a day or two after the hearing, the clerk brought me the answer and said, well, he did answer. So the default judgment against Mr. Verpalat is set aside by the court because it was entered in error. Now, the three third-party complaints are also just sort of hanging out there. And I think all those claims are going to need to be removed to the circuit court.
I believe, Your Honor, the way that I see the case going is that after the damages hearing from Ms. Blair, then we can address the third-party claims against Ms. Stiver and Mr. Patrick Blair and Mr. Verpalat as well. A lot of those factual issues are going to be resolved through the deposition of Ms. Blair. And I don't mean to get sidetracked, but I would like to put it on the record and for the judge to order that Ms. Blair's attempt to seek new counsel will not interfere with my ability to take her deposition. And then over the next 30 days, which I intend to do, even though she no-showed for her prior deposition. So I don't want to there's a common theme here, Your Honor, which is the day before it's judgment day or it's time to show up to the show, Ms. Blair comes with excuses about why not to show up. So I would like it to she be ordered that.
I'd ask you to stand by the microphone because she's getting her
Feedback.
Well, but she's getting it through the microphone.
Over the next 30 days, I would like it to be ordered that Ms. Blair will show up for her deposition to be taken, and that it will not be impacted by her attempt to seek new counsel.
All right, you can give her 14 days. The deposition shall not be scheduled. Ms. Blair, would you turn that down a little bit? No deposition for 14 days, but it may be between 14 days and the 28th of June, and she shall appear unless she is excused by the court. not some doctor who I don't know who signs his name differently 2 different times. So they have 14 days, and he's going to depose you and put you under oath and ask you a bunch of questions. And you're compelled to answer under oath, and you're compelled to appear unless I excuse you. And it won't be until at least 2 weeks have passed. Then all these third-party complaints are just sort of in the background. I've got some time constraints, and each of the third-party defendants has their own concerns, and they've had to retain counsel. So let's see what we can do on June 28th to get this case to the finish line.
And I'm, to hold the claims against the third parties in advance, but Judge, that brings another interesting issue. Mr. Hauser represents Patrick Blair and Karen Stiver. So I don't know if he has withdrawn his counsel for just Rosemary Blair, or if the request was made, I don't believe in the motion it was made for Patrick Blair and Karen Stiver, but he did file an answer on their behalf. Not to add more.
Then
issues.
he's still in that case. So if Ms. Blair and Mr. Blair and Ms. Stiver want to not have him, they have to address that with him and he can move to withdraw, but he's still counsel of record in those 2 cases.
Sure. So to bring it all together, Judge, I think that I don't want to do anything with the third-party complaints before the 28th, because we obviously are seeking attorney fees and costs for our damages against Ms. Blair. I don't want there to be an argument about, you were doing stuff for the Mark Verpalat claims and the Karen Stiver and Patrick Blair claims. So to keep it really clean, we can keep everything to Ms. Blair, Rosemary Blair, until the 28th. And then if those other claims don't resolve themselves, then we can pick those back up in an expedited manner.
All right. Well, here is another thorn in the side. The statute, MCL 600-5739, the amount of money sought by a claim or counterclaim shall not exceed the amount in controversy that otherwise limits the jurisdiction of the court. This court has $25,000 statutory jurisdiction. On the court's own motion or the motion of either party, all money claims and counterclaims exceeding the district court's jurisdiction must be removed to the circuit court in accordance with MCR 4.002. If the money claim or counterclaim is sufficiently shown to exceed the court's jurisdictional limit. I don't want to dump this on the circuit court. I'd like to resolve it here, but the statute says must. So new counsel, Mr. O'Brien or whoever comes in, may raise that issue. And costs and damages are 2 different things, and attorney fees are something different altogether. But it says all money claims and counterclaims exceeding the court's jurisdiction must be removed to the circuit court. So take a look at that. And that is a shadow looming over these proceedings.
I think there's an easy answer to that question, Your Honor, which is after we establish the amount that Mr. O'Donnell and Ms. Bowers have paid Ms. Blair, then we have a balance left on the land contract. That balance left on the land contract will be set off in recoupment from our damages. So there wouldn't be an affirmative award of damages exceeding $25,000. It's just going to come out of the kitty about whatever Ms. Blair claims that she's owed the $300,000 for the remainder of the purchase price. So it wouldn't exceed the jurisdiction of this court through set off and recoupment over $25,000.
All right. Again, I don't think she understood anything you said, but we'll address that.
Well, what, can I say something, Your
Yes.
Honor? I mean, I'm no judge. I'm no lawyer. I don't know all, but I have damages that exceed over $25,000 that happened to me.
All right, that's your claim. Right now, this started out as a termination of tenancy.
Correct.
Action. You wanted them
Correct.
to move.
No,
And
I wanted them to do what was right. That's all I wanted, Your Honor. They could have not gone in the house.
Your
when
Honor,
the
again, I'm just
placard-
gonna
Stop.
object.
Yes. You filed an action to remove them from the house.
What do you mean?
You filed a termination of tenancy action.
Right,
So this started as a termination of tenancy. I do,
because they wouldn't get out of the house when the placard, and you signed the thing, they couldn't, dog, animal,
all right.
no one could stay in the house and hear if the front.
Stop, because you're sort of testifying, and you're the party, so you're right, things you say can come back to haunt you. All right, anyway, you asked, and Miss Hines was adamant, she wanted them kicked out of the house. And Mr. Yonker wrote him a letter and said, you got to get out of the house immediately. We're using the condemnation clause to terminate this agreement. So it was a termination of tenancy. They wanted them out of the house. The condemnation had already been resolved by the time we heard this. The problem had been rectified, and the house was habitable sometime later that fall, I think September.
No, November 16th.
All right.
November 16th is when the placard came
Okay.
off.
All right. So our hearing was after that.
Yes,
Okay. So you wanted them to move. I denied that order, saying they don't have to move. I believe this violated the lockout statute, and they have a purchase sale agreement. So I allowed them, after several adjournments and delays, to move back in the house, and I set the rent at $2,000 per month. They're paying that to me. So far, I believe they've paid May and June. I think the court has received $4,000. And they will continue to pay that to the court while this matter continues. And then depending on how it turns out, they either get the money or you do. But the termination of tenancy case is denied. But, all right, so let's say we go through and let's deny. Well, the period of he continually calls it a land contract. I'm not sure that it is a land contract. It's called lease option to purchase. Which is different than a land contract, because if it was a land contract, they've got to be given time to cure and 90 days or 180 days. So I think it's a lease option to purchase and not a land contract. But at any rate, it's expired.
you're right.
Because we've been fighting this legal fight for 6 months now. It's expired. So their time to purchase the house for that price has expired. They contend it expired because of the actions of our landlord. And we wish to enforce the terms of that contract. We wish to purchase the house at that price. And one of the things I granted in the default is a specific performance, that they be allowed to purchase the house at that price. Now, right now, there's no time limit on it. I probably would calculate the time that was left at the time they got the notice to quit. But that's what they want. I think you understand that. They want to purchase the house at that price. Now, they want to offset it by money they've claimed they've already paid you. So $450,000, and they claim they paid $112,000.
24.5 of it was for option to purchase, which is non-refundable.
All right,
and not against the purchase price.
No, I don't think that's what it says. And it also, they want to offset all their expenses. So a $100,000 attorney fee would be applied toward the purchase price of the house. So you need a lawyer, and I'm giving you until June 28th to get one. And if you don't have one, you have to appear yourself and do the best you can. This is a civil matter, not a criminal matter. You don't get a court-appointed attorney in in a civil matter, although frankly, there is some legislation percolating around to give tenants the right to have court-appointed counsel. But that's not currently the law. I don't think landlords would get court-appointed counsel, but tenants may get it. Anyway, there's a lot at stake here. There's a lot of money at stake. There are complicated legal issues, and I understand that you're not prepared to represent yourself in those complicated legal issues. So I'm not trying to threaten you or frighten you or intimidating you. I'm trying to alert you to the fact that the waterfall is not very far away and you're about to go over it. That's why I strongly encourage that the parties resolve the case to save lots of attorney fees and gnashing of teeth and wailing. But we'll address it further on June 28th. Nobody wanted to adjourn it, but I don't see another answer that's any better than that. So I will do the order setting aside the default on Mr. Verpalat. I will do the order granting the plaintiff's motion to adjourn. And Mr. Hatch will do the order to deny the motion to set aside the default. Anything further?
Nothing further. Well, a couple things, Your Honor. Would you like me, because it seems like the motion to withdraw actually requested an adjournment of the hearing, so I'm happy to prepare a 7-day order and say the motion to withdraw, so we have it in the file, was granted, or excuse me, was granted with the adjournment as part of that motion. So I can do it all.
That's fine. And put the adjournment date to June 28th at 8:30.
And then I'll also draft the order for the notice to set aside the default, which is denied. My only other point that I'd like to bring up, and I know it's the Friday before the holiday, so I won't keep it too long, is we would be happy to participate and facilitate a mediation before the 28th, which I think is a big part of this case that hasn't happened yet. I think if we got a good mediator, if we brought the parties together, if we took a day or an afternoon, then we might not need to proceed with the gamut of issues of this case.
Well, here in this court, we use the Citizens Mediation Authority, which is out of St. Joe, and it's responsible for about 6 counties in this corner of the state. They do a very good job. I don't send very many cases to them. Some judges dump all kinds of stuff on them. I use them only when I think it's appropriate. This is an awfully big case for them. If she gets counsel, you can discuss that with them and I can try to help set it up. We don't have the same kind of facilitative mediation they have in circuit court, but I think mediation could help. I'm not afraid to do this, other than it just takes lots of time and there are a lot of legal issues and I don't want to make any appealable issues. But everybody's better off if the parties can come to a settlement. So that's certainly something I would consider.
And that's right up the line, Your Honor. I wasn't suggesting that, the court didn't want to take the time for this, but I think that Ms. Blair sees this, the light is red and we see the light is green. And I think if we took a day to come together, like I did with her lawyer at the deposition she didn't show up for, I think that would resolve a lot of the issues.
I'm sorry.
You're fine. You're doing the best you can. And frankly, it's only the first or second time we've used it. So
First time I ever used it.
Well, you don't need to apologize. We'll work the bugs out. But as long as you can hear us, we'll be fine. What he's suggesting is that perhaps the matter be set to mediation. There's not a lot of time, and there are a lot of issues. And if you need my help, I will do what I can, but she's going to need legal advice.
Thank you.
All right. Now, again, why don't you do an order regarding the deposition as well? It shall not be before 14 days, but she shall appear unless she's excused by the court.
Okay. Do you want me to do a separate order for that?
Now, the problem is that was going to be at Mr. Hauser's office.
Mr. O'Brien's at Grand Rapids, if she just chooses to.
All right.
And again, I don't want to.
Well, it'll be where her attorney is.
I think we've had that motion before, and I think the court spoke on that. So she didn't want to come to Grand Rapids before, which.
Or you could do it here at the courthouse. We'll make space available here.
Well, Your Honor, we would ask that. I do it at her lawyer's office. I'm in Grand Rapids. Her lawyer's in
Oh.
Grand Rapids.
All right. Well, that's fine. Whatever you guys can come up with. But right now, he's not our lawyer. Mr. O'Brien might say, I watched that video and I don't want to touch this with a 10-foot pole. So I don't know. We'll see where this takes us. All I know is we're going to resume on the 28th of June at 8:30 in the morning. All right, Miss Blair, nothing's going to happen. The status quo remains in effect. If you haven't paid June's rent, you're to pay it to the court. And everything else, you have possession of the premises. There are also those issues about personal property, wave runners and trailers and stoves and refrigerators. And so a mediator could help with that too, I suppose. All right, we are in adjournment. And Miss Blair, I will see you on June 28th at 8:30 in the morning.
When do I ever get to say anything?
Well, you don't, because I've granted your motion to adjourn.
I mean, but when I get new counsel, do I get to talk?
Oh, yes, you can get under oath and you can tell your whole side of the story to your heart's content. I'm not going to prohibit you from telling your side of the story. I didn't want you to do it here today. One, you're not under oath.
And I'm not an attorney.
And
I
you're not
haven't
an
talked to-
attorney. So when you have an attorney, if you want to tell your side of the story, and that's what he wants to do, I'll listen to everything you have to say. There are
Thank
two
you.
sides to every story,
Thank you.
sometimes more. I'm going to put on my tombstone, the truth is somewhere in the middle. Anyway, we'll resume on the 28th of June.
Thank you, Your Honor.
Thank you.
You can just leave that right there.
Rosemary.
Rosemary, you can leave it right
Oh, you just leave it right there.
Leave them here? Okay,
Thank
thank you.
you.
Thank you. You're welcome.
Mr. O'Brien, quick.
Get the attorney, he said. Oh, yeah. Yeah, we had to. No, I was there when I came in. No, we didn't bring anything.
1 hour later.
This was all part of it?
Yeah, look at these.
Who brought these?
Mr. Hatch for the defendants.
Oh. Because she was saying they didn't pay me any money. What did she say about these?
Well, we didn't get to it.
That's a who. You say, did you win the lottery?
Well, it even looks like they got a screen capture from the drive-through at the bank. Down here on the right.
Where?
That
This
one.
one's. She Rosemary?
Yeah.
Rosemary, 7/1/2022. What the flip? So right here. Oh my God, lease with option to purchase.
Yeah.
The money's right on top of it. 1, 2, 3, 4, 5, 6, 7, 8, 9, 10, 11, 12, 13. That's $14,000. It looks like, right? Oh, there was 14,400. Did she
So-
what?
He was, Hatch was chomping at the bit.